So for the Companies Act 2013, there was a bill which was presented in the parliament, that is the Companies Bill 2012. The bill was presented in the parliament, that is in the Lok Sabha, in December 12. Then subsequently, with some modifications, it was again passed in the Rajya Sabha in August 2013. And in August 2013, the president has made it finally the law of the land. Now, how the Companies Act is actually enforced, or in for that matter, any law, how it is actually mentioned or how it is actually being made effective. Firstly, you need to present it in the Lok Sabha, then in Rajya Sabha, then in present. What I had not mentioned in this slide, there is one more point. Only president's assent or president's signature is not enough. Pursuant to or subsequent to the president's consent, it must be officially notified in the Gazette of India or in the state gazette. The president's assent will be followed in of its publication in the official Gazette of India. Once the Gazette of India has notified a particular law, it becomes the law of land. And for that matter, any rule, any order, anything, it actually defines a proper procedure of how it will be made effective. So in this case, when we were talking about act, the bill will be presented. How the bill will made an act? The bill will be presented in the Lok Sabha, then Rajya Sabha, then president, and subsequent to the president, it will be notified in the official Gazette of India. जिसे हम हिंदी में बोलते हैं भारत का राजपत्र. So once it has been notified in the official Gazette, it finally becomes an act. So far, we had discussed the basics of the Companies Law and Companies Bill. Now, in this particular act, which is effective, one thing very important. Now, on 29th August 2013, the Companies Act 2013 came into force. Now, how it came into force, let us discuss. The president's signature, that this is the final law of the country, that was on 29th August 2013. But it was subject to the condition that this act is not made applicable from the current date. This is a power of president. The president has signed the act with the power to make this particular act effective from 1st of April 2014. If he had not signed the bill with such condition and there was no clause of 1st April 2014 in his signature, the bill would have become the law of the country on 29th August 2013 itself. But this was not the case in company law. The company law, the Companies Bill became the Companies Act 2013 on 29th August 2013 itself, but it was not applicable on India. The previous Companies Act 1956 continued to remain in force in 2013 and till 1st of April 2014 because it was so effective. So the effective date of the Companies Act 2013 was 1st of April 2014. The logic was very clear. Let us start the new act with the new financial year. No other reason was involved. So that you can make all the accounts from the very first day. You can make all your compositions of board of directors, general meeting and everything from the very first day of the financial year. And of course, from 29th August 2013 to 1st of April 2014, the corporates were given the time to adjust all your compliances accordingly so that from 1st of April, you can comply with all the provisions. In this particular act, we have 470 sections divided into 29 chapters. Apart from the 29 chapters, we have 7 schedules. What are these 7 schedules? We will be talking in the next slides. And what are the 29 chapters? Let us have an overview. So this particular slide defines our 470 sections divided into 29 chapters. This is the Constitution of Companies Act. So the preliminary, we have the first chapter preliminary followed by incorporation. I'm not taking the names. You can check this PPT. Prospectus, allotment, share capital, accounts, audit, then most important, the directors, very important segment of the company law. And apart from it, compromise arrangement, then winding up, and then some other chapters as well. So all in all, the Companies Act is divided under 29 chapters constituting 470 sections. You can refer this slide for the composition of Companies Act. Now, apart from the 470 sections or 29 chapters, we have 7 schedule at the end of the Act. Schedule actually defines some formats, some depreciation rates. The first schedule defines the memorandum and articles, formats of the memorandum and articles to be used, which can be used by different types of companies. We'll be talking about the types of companies. 5 types of companies have been defined, and various memorandums of these 5 types are defined under table A to E. And for those 5 types of companies, table F to J of the first schedule defines the format or model AOA. What we call schedule first model MOA and model AOA under the Companies Act, which is pursuant to the sections 4 and 5. Of course, we have other schedules as well. Depreciation, how to calculate the depreciation, that is WDV. How WDV is defined by the useful life that is prescribed under schedule 2nd. The formats of trading P&L balance sheet are defined under schedule 3rd, part A and part B. Part A defines the balance sheet and part B defines the P&L, the statement of P&L under the company. We have the independent directors under section 149, 6 and 7. 4, 5, 6, 7 deals with the independent directors. We will be talking in the 3rd or 4th week, I guess. The code of how the independent director will perform their duties is defined in the schedule 4th. Next thing, the schedule 5th defines with the managing director, whole-time director, and manager. Keeping aside the manager, who are the managing director and whole-time director? They are the executive directors of the company. There is a difference between executive directors and non-executive directors. Executive directors are normally the employees of the company, and they are either categorized as managing director or the whole-time director. And apart from the executive, that is employee directors, we have non-employee directors as well, who just come to the decision making, that is the board meeting, attend the board meeting, and they leave the company after attending the board meetings. They are not the full-time employees. They are not the executives. They are called non-executive directors. We will be talking about the same. Next is schedule 6 defines the infrastructural projects, and one of the very important schedule 7, which all activities are categorized as CSR under 5 under the company law. We have taken the class of CSR as well. So these are the 7 schedules which are attached with the Companies Act 2013. So far, so good.